In the Election Commission's own guidelines, it was stated firstly that it is not the job of the enumerator to determine citizenship. You yourself are not to determine their citizenship. You can refer those cases to those authorities under those acts. Once those authorities determine that you are not a citizen, then you can remove the name on the ground of citizenship. What we do know is that about 3.5 lakh people's names were deleted from the draft electoral. The 3.5 lakh names more were added before the voting, between the time of the publication of the final roll and between the time of voting. If your lordship sees guidelines, Form 7 is for objections to somebody's name being included in the electoral roll. And guidelines number 3, it says the applicant has to take any one option in which he intends to make the application. It can be permanently shifted, already enrolled, or not Indian citizen. He must also take any of the reasons mentioned below the option as to why the person against whom the objection is made is not qualified for inclusion. He has to give reasons. That is, due to death, underage, absent, permanently shifted, already enrolled in the electoral roll, on the etc., or not being an Indian citizen. The onus of proof to substantiate the reason given for objection to removal of name lies with the applicant. So you have to give reasons as to why you believe that this person is not a citizen, and the onus of proof is also on you if you want somebody's name to be deleted.
That can't be any doubt. If there is somebody a voter in the voter list, you can't exclude without giving a reason.
Yeah, you can't, and the onus of proof is on the person who objects. This is all that I wanted to show. Now, your lordship may see their own directives of Election Commission in the case of Assam. Before that, my lord, your lordship may see the directions in the SIR guidelines of 2003. So now Election Commission refused to share the guidelines of 2003, which the Election Commission itself had issued. We obtained those guidelines from a whistleblower. We have filed them. Now see the guidelines. Lord, that is in volume.
It's an additional affidavit dated 8th October. I had given it in the list.
Starts at page 47. This is now Election Commission's own SIR guidelines of 2003.
Yes.
Para 32, page 51. It is clarified. Has your lordship got it?
Oh, para 32 is page 60 probably. It
Yes.
is clarified that it is not
Yes.
the job of the enumerator.
It is clarified. Now, very clear instructions in this SIR. It is clarified that it is not the job of the enumerator to determine the citizenship of an individual. However, they have the power and responsibility to exclude any person on the basis of qualification for registration regarding age or ordinary residence. Age can be verified with reference to, but not restricted to, the birth certificate, school certificate, passport, whatever, wherever available, baptism certificate, etc. Ordinary residence may be checked with reference to various other documents. It says, in case an objection is filed in Form 7 seeking deletion of name from the electoral roll on the ground that the person objected to is not a citizen of India, the onus of proof shall lie on the objector. It shall be ensured that such onus is discharged in accordance with law. So, my lord, in this SIR of 2003, in the Election Commission's own guidelines, it was stated firstly that it is not the job of the enumerator to determine citizenship. And secondly, that if somebody objects on the ground of citizenship, onus of proof is on that person. Now, my lord, your lordship may see their directives in the Assam revision, volume 4A, part 2, page 448.
Yes.
Verification by electoral registration officers. And 2, the electoral registration officer should ensure as far as possible that only names of Indian citizens are borne on the electoral rolls. But basically, it is not the electoral registration, not for the electoral registration officers to determine whether a particular person is a citizen of India or not. This determination is to be made by authorities with responsibility under the Citizenship Act, the Foreigners Act, and the Illegal Migrants Act. However, the electoral registration officer has to decide for the limited purpose of preparation revision of electoral roll whether a person is eligible for inclusion of his name in the electoral roll or not on the ground of citizenship, as citizenship of India is an essential condition for such registration. Now, Lord, what does this mean? This means that if a person has been declared to be a non-citizen by any of those competent authorities under those three acts, then yes, you remove their name. But you yourself are not to determine their citizenship. You can refer those cases to those authorities under those acts. Once those authorities determine that you are not a citizen, then you can remove the name on the ground of citizenship. That is the directive. Then, my lord, 451, para 8.8. The electoral registration officer shall, on receipt of verification reports from the local verification officers, consider the same. Where he is satisfied on such report and such other material information as may be available about the eligibility of a person, he shall allow his name to continue on the roll and include it in the final roll. Where, however, he is not so satisfied and has reasonable doubt about the citizenship of any person, he shall refer all such doubtful cases to the competent authority under the Illegal Migrants Act or Foreigners Act, or as the case may be. For the convenience of the electoral registration officer, the Commission has devised a pro forma for making such a reference, which shall be adopted by the EROs. While making such a reference, the ERO shall furnish to the competent authority all documentary information collected for this purpose, etc. Then, my lord, 8.9. Pertaining to the person concerned, and shall also inform the person concerned about the case having been referred to the competent. 8.9. After the ERO has referred the case of a person as aforesaid, he shall await the decision of the relevant tribunal in relation to that person and act accordingly to such directions. So therefore, my lord, very clear. First, my lord, from the judgment in Lal Babu Hussain, Inderjit Barua, thereafter, my lord, from their own SIR guidelines of 2003, thereafter from their own special directions given to Assam, that it is not the job of the ERO, etc., to determine citizenship. All that they can do is to refer it. If they feel that your citizenship is doubtful, then with the reasons for that, they can refer it to the competent authorities and await their decision. Whether it is the Home Ministry under the Citizenship Act, whether it is a foreigners tribunal, whether it is a court, these authorities alone will determine, just as below, unsound mind. Unsound mind is also a ground for deleting a person's name, but that determination has to be made by a court and not by the Election Commission. Then, my lord, and they have also directed on the next page, page 452, in this, that the directions given by Lal Babu Hussain have to be followed. Para 5 on Roman 5 on page 452, they have referred to Lal Babu Hussain, quoted Lal Babu Hussain, and said that these are the directions that you have to follow. Then, my lord, coming to, they have given now what they did in Bihar. Now, we don't have the exact numbers of how many people were issued notices regarding their documents for deletion of the names who were already on the draft electoral roll. What we do know is that about 3.5 lakh people's names were deleted from the draft electoral. They first prepared a draft electoral roll. After that, finally, when the final roll was prepared, 3.5 lakh names were deleted. And even after the final publication of the electoral roll took place, final roll, after that, about 3.5 lakh names more were added before the voting, between the time of the publication of the final roll and between the time of voting. In fact, my lord, that figure, what page kahan gaya that? Just take this, this will give your lordship a bird's eye view. This is from the Election Commission's own records. There is no doubt about these figures. When SIR was announced, my lord, there were 7,89,000 7 crore 89 lakh people in the electoral roll which existed.
Oh.
Thereafter, my lord, 65 lakhs were deleted from the draft roll. When the draft roll was published, 65 lakhs were deleted. They said that those who didn't fill up their enumeration forms, their names have been deleted. Then, my lord, number of voters left were 7 crore 24 lakhs. Then they say that 21 lakhs plus were added through claims in Form 6 during the period of claims and objections. Now, unfortunately, my lord, they didn't allow the people whose names were deleted, 65 lakhs whose names were deleted, to come in through any other way except by filling Form 6. And Form 6, as your lordship sees, is a form for a new voter, where you have to declare that you were not in the electoral roll. Actually, they were on the electoral roll. So in order to fill Form 6, they would have to file a false declaration that they were not on the electoral roll. Whereas, in fact, they were. Just as in the Citizenship Amendment Act, they are saying that those who want to apply for citizenship under the Citizenship Amendment Act, they have to file a declaration saying that they were citizens of Bangladesh or Pakistan and they came here due to religious persecution, etc. Whereas the fact is that at least in Assam, the vast majority of the people who were excluded from the NRC, who were not in the National Register of Citizens, were not citizens of Pakistan or Bangladesh. They were, in fact, Lord, Indian citizens who didn't have the documents. Today, if you say that for determining citizenship, you have to produce the following documents, any documents, unfortunately, my lord, in a country like India, at least 20-25% people will be excluded, but because they cannot produce any documents in a poor country like India. All that they can say is that I can give an affidavit that I was born here, I have been living here since this time. And I can also give an affidavit of 2 of my neighbors attesting to this fact. They don't have any documents. So therefore, my lord, these people who were asked to fill Form 6, many of them, these 21 lakhs who were added through Form 6, many of them would have been those whose names were deleted from the draft roll, but who were forced to fill Form 6 because the Election Commission said that, look, there is no other way of getting in, you have to fill Form 6 if your name has been deleted. Thereafter, my lord, voters removed through objections in the same period, 3.66 lakhs. But, my lord, day before yesterday, somebody from Bihar, who's a very responsible person, came and told me something very shocking. And this is something which your lordship should ask the Election Commission to specify. They said that though only 3.66 lakh people were deleted through objections, notices were issued to 26 lakh people, 26 lakh people. A cyclo-styled notice saying that, look, your documents are not adequate or your documents are not enough, and therefore you come and prove your case. This kind of cyclo-styled notice.
Those 26, how many were dropped?
3.66 were dropped. Now, what I am told is, what I understand is that in many cases.
Is it that, Mr. Bhushan, out of those 26 lakhs to whom notices were issued, that was approximate
15%,
half lakh,
14%
objections were accepted.
Yes. 86% were accepted, 14% were dropped. But, my lord, the point is, you are issuing cyclo-style notices to these people without giving any reason as to why. These are people who were dropped from the draft electoral roll without giving any reason which the form requires, which the rules require. You give some reason as to what is the problem. What are you doubting? You are doubting my residence, you are doubting my age, you are doubting my citizenship, and for what reason? For what reason? Unfortunately, though the election manual says that all these forms of claims and objections must be put out on the website, must be given to the political parties and put out on the website, none of it has been put out on the website. Therefore, my lord, today, I as a citizen cannot verify, cannot find out how many people were issued these notices. All that I know is that some people who were issued these notices have shown me the notices, and the notices are cyclostyle notices, not giving any reasons for why what is suspected, why it is suspected, etc. So therefore, because one of the issues that we are raising is transparency. It's a very, very important issue. And the standard notices, my lord, we have annexed some of them. They were just, I can tell your lordship that they were just cyclostyle notices, not giving what is it that is being suspected about me? What is it and on what basis they are suspecting this about me? Just cyclostyle notices. You come with your documents to my office and show. What do I show? When Lal Babu Hussain said that you have to give reasons. You have to state as to why a doubt has arisen, as to why your name should not be on the electoral roll. What are the basis for the doubt having arisen? Yet, my lord, that's not been.